to address the issue, as much as they are saying that they are negotiating, but the people down there on the ground are really suffering. Ashley?
Right, thank you very much there, Victor Ogale. Let's now move on. The conflict pitting the legal fraternity on the one hand against President Uhuru Kenyatta and Parliament on the other has escalated, with the judiciary formally notifying MPs that Justice Mohamed Warsame will not subject himself to vetting. In a letter to the clerk of the National Assembly, Michael Sialai, Chief Registrar of the Judiciary, Anne Amadi, is categorical that Justice Warsame, and I quote, will not subject himself to the process of approval by the National Assembly, end of quote, before he can be formally appointed to serve in the Judicial Service Commission. Let's take a look at some of the issues they're raising through Ms. Amadi. All right, so we will be crossing over. We are going to be talking to a lawyer now, George Keithy, and he's joining us by way of phone. But before we do, let's now just take a look at some of the graphics that will be shortly on the screen. And the first one says that the GSC holds the considered view that the approval of the Justice Warsame by Parliament is neither provided for in the Constitution for Kenya 2010 nor the Judicial Service Act 2011. The GSC further takes the view that the proposed approval by the National Assembly as a commissioner of the GSC is unlawful and constitutional, a violation of the express provisions of Section 15(2) of the Judicial Service Act 2011 and undermines the independence of the judiciary. The requirement for Parliament approval is only in respect of persons appointed under Article 171(2)(h) of the Constitution, and these are one woman and one man representing the public, not being lawyers appointed by the President with the approval of the National Assembly. Let's now speak to lawyer George Keithy by way of phone. George, good afternoon. Thank you very much for making time. So why is the judiciary protesting the vetting of Justice Warsame?
Well, the procedure for admission into JSC when a name has been recommended by JSC is such that the appointment is direct. There's a dual appointment that has been established in law under Article 171 and also the Judicial Service Act, Section 15, subsection 2. If you look at the composition of the JSC, all of them are lawyers, basically, and all of them are appointed directly to the membership. However, there is one appointment of a man and a woman who are supposed to represent the public under the Constitution, Article 171, 2H. This person is appointed from the members of the public without a background knowledge as to professionalism and hasn't gone through any test whatsoever of the propriety to serve. The rationale behind it, therefore, is such that this person, although appointed by the President, will be complemented in that appointment, or ought to be complemented in that appointment, by the approval of the National Assembly. As such, the only people or the only persons who are part of the membership and comprising the membership of JSC are the non-lawyers who then have to be vetted. So then the woman and the man who are appointed who are not lawyers, as shall be presented, shall be recommended by the President, must go through parliamentary approval. So the judges who are already serving through an elaborate process of appointment cannot, under the Constitution, read together with the Judicial Service Commission, cannot be taken through Parliament. But more importantly, also, you look at the principle in separation of powers, which is ingrained in the Constitution, is such that then there are no supervisory powers in this context of Parliament, over judiciary, and their appointment. The independence of these two institutions is very elaborate, engraved in the Constitution. And as such, then the cry out by JSC of the constitutionality is supported by the clear text of the provision of the Constitution and that of law.
President Uhuru Kenyatta wrong to submit his name for vetting. The Judicial Service Act 2011 states that the president is supposed to confirm the appointment of a GSC nominee within 3 days of receiving the name without it going through Parliament.
What happens is once the name has been forwarded to the president, within 3 days, he's supposed to appoint, not to recommend the appointment to Parliament or submit it to Parliament for approval. He is supposed to appoint. So it means what follows is gazettement by way of law and not subjecting them to vetting by Parliament, so to speak. So then the appointment, like I've said, there's a dual apportionment of the appointment. The first are the lawyers, and then the second category are those members of public and 171 2H. Those are the ones that will go. But the membership, once recommended, the proposed membership of a person once recommended the president ought to appoint directly without Parliament.